All right, I'm just going to get started with the intro here, as I'm sure more folks will be joining us. We're going to go through this, but I just wanted to get us started so we can stay on time today. Good afternoon. Thank you everyone for joining us today. My name is Jay Fortune. I'm the office manager at Standpoint. My role today is going to be to help facilitate this webinar. So if you have any questions during the presentation, please type your question in the Q&A tab or the chat box, and I'll pass it along to our presenters today. Most of you probably know about our organization already, but for those who listen to this later or who aren't as familiar, Standpoint, we are a statewide organization, a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are our annual new laws throughout the state of Minnesota, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 to 4 p.m. It is through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. This webinar is being recorded, and you can check it out afterwards on the Standpoint's YouTube page. The link to recording will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. For today's presentation, I'll put in the chat box a link to the PowerPoint so you can follow along, which I will put in there right now. And I'm going to share a little information about our presenters today. First, I'd like to introduce Rana Alexander, Standpoint's Executive Director. Rana has worked in the domestic and sexual violence field since 1997. Ms. Alexander joined Standpoint, formerly known as the Battered Women's Legal Advocacy Project, in 2005. Ms. Alexander became the Executive Director in 2016. As an attorney for the statewide organization, she provides legal advice and consultation to domestic and sexual violence victims, advocates, and attorneys on legal issues that affect domestic and sexual violence victims. Ms. Alexander also provides training and outreach to attorneys involving issues of domestic and sexual violence in the law. Ms. Alexander is a graduate of Northeastern University School of Law in Boston, Massachusetts, and received with distinction her Bachelor's of Science degree in psychology and a minor in women's studies from Iowa State University. We also have with us today Beth Assell, as a staff attorney at Standpoint. She joined our team in October of 2020. Beth graduated from law school at Hamline University and directly after graduation clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in these fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps, and brings to Standpoint a lifelong passion for advocacy and helping others. I'm going to pass it off to Rana and Beth.
Awesome. Thank you so much, Jay, for the introduction. Really appreciate this. And I do want to give a shout out when Jay said that we do other trainings by request. This would be one of those trainings by request. Dana and Gina, who are victim witness folks up in Polk County, contacted us and asked us if we would do a training about jurisdiction, because up there they have a lot of crossover into North Dakota. And the closest shelter is in North Dakota. And so they see a lot of jurisdictional issues. And then they were gracious enough to allow us to not only do this training for them, but also open it up for everybody else who is not up in that region. So thank you very much to Dana and Gina for bringing up the idea and for letting us open it all up to everybody else. And I already can't remember, Beth, do you go first or do I?
Yeah, I start. So yes, perfect. Thank you so much, everyone, for joining us for the really exciting world of jurisdiction. And thanks to the folks who suggested this presentation. We really appreciate it. So we're just going to start with kind of the basic question, why we're here. What is jurisdiction and what does that mean? And so jurisdiction, if you've heard that referred to, well, obviously during this presentation, but also during court or from an attorney, jurisdiction refers to the official power of the court to make legal decisions and judgments. And so a court must have jurisdiction before they can make any decisions on a case, which includes a child custody So we're here today to specifically focus on family law cases, child custody, parenting time. So that includes jurisdiction. A court also has to make sure they have jurisdiction over those issues. So when you're considering jurisdiction, the big question to ask yourself and the big question for courts to ask themselves is this the right court to hear this specific issue? Is this the right court to make the decision that's in front of the court at that time? Trying to go to the next slide. There we go. And there are a few different types of jurisdiction that you may hear referred to and that we may refer to over the course of this presentation. So just some background on that and what we mean. Personal jurisdiction is the court's jurisdiction over the parties, like the parties of the case. They must have some kind of contact with the state, and the court has to decide that they have personal jurisdiction over those parties. In addition, the courts also have to have what's called subject matter jurisdiction, which instead of being jurisdiction over the parties is jurisdiction over the topic itself, the topic that's in front of the court. So the example I have here is that if the issue is in front of the court is a matter of bankruptcy, only the bankruptcy court can hear that matter. The bankruptcy court has jurisdiction over bankruptcy issues. And then separate from the issue of jurisdiction, so separate from personal jurisdiction and subject matter jurisdiction, is the concept of venue. And that would be the legally appropriate place to commence an action. So you can think of venue in terms of county, like what county do you file in? Which county is the appropriate venue for this particular action? And a court can exercise jurisdiction over a non-resident. So the court can have what's called that personal jurisdiction. We just talked to someone who isn't even a resident of a state, as long as that person, in person or through an agent, does one of these four things. So if they own, use, or possess any real or personal property that's situated in this state, if they've transacted any business within the state, if they've committed any act in Minnesota that causes injury or property damage, or any act even outside of Minnesota that causes injury or property damage in the state. So you can see those are four pretty broad things that I think can lead to jurisdiction over a lot of non-residents. And so even if someone doesn't live here, they can still be subject to a lawsuit here if those certain factors are met. And so one example that many advocates would have seen is that you can file an order for protection in Minnesota, even if the respondent doesn't live in the state, if they're causing harm in the state by committing abuse here or causing some kind of harm in the state. So a question, again, looking back at family law cases like custody and parenting time actions, a question might be, where do I file that action, or where should that action be filed? So let's focus specifically on, for this question, a petition for custody, assuming that both parties live in the state, live in Minnesota. A petition for custody can be filed where the child is permanently a resident, where the child is found, or where an earlier order for custody has been entered. And we have the site there, the statute site. And so that's for a custody case. Compare that to a divorce case. For a divorce, the law is pretty clear that you can file in the county where either spouse lives. But for a custody case, you file where the child lives. It can be helpful to know if you have a case where the parties live far apart, even in the state. So if it's, in that case, the dad initiating a custody action, he should not be filing necessarily where is most convenient for him, his home, but where the child lives. Next slide, even a bigger question comes, and it becomes more difficult about where to file if one party lives out of the state, right? So if we have maybe mom living in Minnesota, dad living out of state, the question of where to file that custody action can become more complicated. And that's the kind of case where it's really important to decide which state has the power to hear that case. So which state has jurisdiction. And what governs that decision is called the Uniform Child Custody Jurisdiction and Enforcement Act. It's referred to as the UCCJEA for short. We've highlighted, let's see, 5 states here where the UCCJEA is the law, highlighting those states because it's here and then our neighbors. But the UCCJEA was drafted in 1997 and it's been adopted by 49 states. So it's pretty much the law everywhere here. Every state and territory, except for Massachusetts and Puerto Rico, are the two holdouts that have not adopted it at this point. But so again, the UCCJEA comes into play, and we'll go over a lot more about what that means and kind of boil down what you need to know. But that comes into play when you have parents living in different states, and some court needs to decide custody and parenting time. And the purpose of the UCCJEA is to have some kind of uniformity and consistency across state lines. Before this, there were some situations where parents were maybe trying to take a child across state lines and find a state that would modify the terms of an existing order, maybe find a forum that was more appropriate. And so the goal of this is to have more uniformity and consistency when it comes to these child custody and parenting time decisions.
Don't shoot, go back. Okay.
There you go.
Yep. So when we're trying to figure out, so what state has jurisdiction? If we have parties, if both parties live here in Minnesota, we know Minnesota has jurisdiction. And then it's just a question of what venue, what county is going to make the most sense. And that's going to be based on where the child is, if we're talking about custody, or where either party lives, if we're talking about a divorce that doesn't involve children. And when we're talking about an order for protection, that's a whole different thing because residency doesn't really apply. And it's just literally where the petitioner is going to make their home, like where they currently are, where they are planning on making their home, or where the respondent is, or where the abuse occurred, right? Or where there is a family court action. But we were asked to kind of focus on the family court stuff. And so that's why we're talking about the UCCJEA today. So we know that if both parties live in Minnesota, it's going to be Minnesota. But what happens when both parties don't live in Minnesota, or they haven't lived in Minnesota, as we'll find out, for 6 months yet? So things that you need. So there's first set of questions you need to think about. So is one of the parents, or the child, living in another state? And there's a case that involves custody that needs to be initiated or modified, right? So that's your first question. Do we have a parent or a child of those parents, and they're living somewhere else? And living means not visiting. Living means like that's where they live. They have a driver's license. They have where they pay rent there. They have a job. Probably not, maybe not, the child doesn't have a job. And maybe, but where is the child going to school? Where do they go to daycare? So is somebody living outside of the state of Minnesota? And we also need to remember that the UCCJEA only refers to custody and parenting time. It does not apply to divorce. That's covered under different statutes. It doesn't apply to third-party custody. This is about custody in between 2 parents, and it's custody and parenting time, as we call it here in Minnesota. Something else to always remember, while personal jurisdiction can be waived and really, really easily. So if you're ever feeling like that you've been called to a state to have to, defend against a lawsuit, you want to raise personal jurisdiction right away. Like you don't want to make any other arguments. You want personal jurisdiction to be your argument. You're only submitting a motion for the purpose of arguing personal jurisdiction because you can get waived really easily. Subject matter jurisdiction, which is what in general what the UCCJEA is addressing, that is something that can be raised always. If the court did not have subject matter jurisdiction, if Minnesota was never supposed to have jurisdiction in this case, it can be raised at any time. So even on appeal. So it's really important to get this right, because just because you won and now you have it here in Minnesota, it doesn't mean, or that nobody raised it, it doesn't mean that I can't come up later. So keep that in mind. Over here, over there. All right. So you want to ask yourself a series of questions when trying to figure out, are we here in Minnesota or are we possibly in another state? So the first question is there a prior state or tribal court order regarding child custody? So do we have any orders that already exist out there? And this could even be a protective order that gives custody or parenting time in it. So we're talking about very broad when we're thinking, are there any other orders, state or tribal, that establish any sort of child custody? The answer is no. Then the next question is, which court has initial jurisdiction? And we're going to talk about that in a little bit. If the court has initial jurisdiction, should the court decline that jurisdiction? And we're going to talk about that. If, say, Minnesota doesn't have jurisdiction, is there a possibility that Minnesota could take what's called emergency jurisdiction? And we're going to talk about that. But we're going to start by talking about, so you ask if there's a prior order involving child custody, and the answer is yes. So we're going to talk about that first, and what would be the next line of how to deal with that.
Right. So like Rana said, yep, that's me. Very first question, if a client comes to you, right, and they want to discuss custody and parenting time, first question to ask, is there an order that already addresses this? Like Rana said, state or tribal, even if it's not in Minnesota. If so, if there is an existing order that already addresses custody and parenting time, that state that issued that initial order has what the UCCJEE refers to as continuing exclusive jurisdiction. And so only that state can modify the custody order unless one of these other things is true that we'll go through. That state that issued the initial custody order can decline to exercise further jurisdiction on the basis that it no longer has that continuing and exclusive jurisdiction, because it decides that it doesn't have substantial evidence regarding the child's care, protection, training, personal relationships. That state, so that initial issuing state, can determine that a court of another state would be a more convenient forum, or either state, so the state where you've moved to, or that prior state that issued the initial order, can determine that the child's parents, or any person acting as a parent, don't reside in the issuing state. So basically, if that initial state issued a custody and parenting time order, but no one lives there anymore, they can decide, that first state can decide they no longer have jurisdiction to keep making decisions and modifications regarding the child, or a new state can just say, it looks like no one moves there, and make that determination. So we just had a couple notes I think we wanted to raise on this slide about the concept of continuing and exclusive jurisdiction. One is that Minnesota, as we've covered in, I think, other family law presentations, and has a pretty strict move out of state standard of parenting time has been ordered. Meaning that if the non-custodial parent has parenting time ordered, the custodial parent can't move the residence of the child out of state unless that custodial parent, the one wanting to make the move, has permission of the other parent or permission of the court. And so just a note that if a custody and parenting time decision is made in Minnesota and the custodial parent moves across the border to even like to North Dakota, let's say just across the border, it could be a violation of that move out of state standard that we have, because Minnesota still has exclusive continuing jurisdiction. And also another note that even if your client files an order for protection here in Minnesota and asks the court here in Minnesota to determine custody and parenting time in that order, that could be considered an initial custody order, meaning that it gives Minnesota that jurisdiction. So if your client ever wants to move out of state in the future, that's just something to take note of, that asking even through an order for protection to establish custody and parenting time here through an order for protection could be giving Minnesota jurisdiction, meaning that Minnesota would have that exclusive continuing jurisdiction unless one of these three things applied here. Okay, and I went too far. And this is just a note we wanted to have, that when you're looking at if there's already an existing court order, even out of state or tribal, to see if that initial state has to be the one to make any modifications. That includes international orders. Courts are required to treat foreign countries as if they were states and apply the UCCJEA unless the child custody law of the country violates fundamental principles of human rights. To be honest, I don't know an example of that, but that is the law, that you have to consider a foreign country as if there's an existing order from a different country. And also, if a state has enacted the optional UCCJEA provision regarding tribes, as most have, states must also treat tribal court orders as if they were entered by another state. Okay, so we have an example here, hopefully to illustrate this concept a little better. But the example that we have is we have a parent A and a parent B. And let's say they obtained a custody order in Colorado. Through that custody order in Colorado, parent A received permission to move to Minnesota with the child, but parent B remained in Colorado. Let's say parent A moves to Minnesota with permission, and there's that existing parenting time order in Colorado, but something's just not working. They don't like the schedule. Let's say a child's supposed to go home for the summer, it's just not working. They want to modify it. If parent A wants to modify that existing Colorado order, they have to return to Colorado either to modify there or ask Colorado to give up jurisdiction to Minnesota. So that parent A, again, that's the moving parent, the one who got permission to move to Minnesota. They can register their order in Minnesota for the purposes of enforcement, of enforcing the order, but Colorado hangs on to that ability to modify until Colorado orders otherwise. And parent A can bring a motion in Colorado asking to move jurisdiction, but Minnesota can't act until this is done. And again, this example is assuming that parent B, is it parent B? I'm losing track. Yes, that parent B remains in Colorado, so they still have a parent there. They're still kind of an anchor in Colorado. If parent B moved out of Colorado too, that might be a whole different ballgame, but this is an illustration of if a parent stays in Colorado, Colorado hangs on to that continuing exclusive jurisdiction until Colorado makes that decision to give it up. Okay.
All right. So what happens if we have another state that has exclusive and continuing jurisdiction, and a parent wants to try to argue that the state that they have moved to with the child, because the child has to be present to even try to apply any of these things, wants to argue that that state is no longer a convenient forum. So let's say that parent A wants Minnesota. And so in our prior example, parent A wants Minnesota to take jurisdiction from Colorado and is going to argue to Colorado that Colorado is no longer a convenient forum. Well, the UCCJEA, as adopted in Minnesota and as in 48 other states, gives an outline. It gives 8 different things that the district court can look at in determining whether or not that state continues to be a convenient forum. And number 1 is domestic violence. So whether there's been domestic violence that has occurred and is likely to continue, in which which state could best protect the parties and the child. Right. There are some other things that the court could consider, but largely for our purposes, we consider this domestic violence piece. right? And trying to argue that, you know, maybe the reason that parent A wanted to leave Colorado is because parent B was abusive and it was very scary and bad things were happening. And so parent A, now it would be unlikely that parent B would have disagreed because that doesn't happen much in our world, but you know. But maybe parent A came to Minnesota and there was domestic violence. And so they want to argue Minnesota is a more convenient forum because it is safer for parent A to be here in Minnesota, and it's safer for the child to be here in Minnesota and have Minnesota to decide these things because there was domestic violence in Colorado, and it's likely to continue if they were to have to stay in Colorado. There are some other things that the court can look at: the length of time the child's been out of the state, the distance between the courts in the state and the court that would assume jurisdiction, and that's the distance for the parties. So how far are people going to have to be traveling? What's the financial circumstances of the party? Do we have the party who moved to Minnesota has greater financial ability than the party who lives in Colorado? We have that, then it might lean more towards leaving it in Colorado because parent A has more money and can fly back to Colorado. Like, that's an option for parent A, but it really isn't an option for parent B to fly to Minnesota. Are there any agreements? Did parties ever, like, so in our example of A and B, we had parties who agreed that that they could go to Minnesota. Maybe there was an agreement that Minnesota should take jurisdiction. Is there any, where's the evidence that exists that could resolve this litigation? Is that in Minnesota? Is that in Colorado? Whatever. What's the ability of the court to do so expeditiously and has procedures necessary to present evidence? I don't think any court's ever going to admit that, like, oh no, it's going to take us forever to do this one. That should be a reason that we wouldn't, but it is in the statute. And then what's the familiarity with the court of the facts of this case and the issues of pending legislation or litigation, I mean. So these are the 8 things that the court is supposed to consider when trying to decide whether they are a convenient or an inconvenient forum. And again, the court that's making this decision is the court that currently has continuing and exclusive jurisdiction over the case. Right? So it's not that the new court, the court you want to go to, they don't get to decide. So in our Colorado, Minnesota case, Minnesota doesn't get to decide that Colorado is inconvenient. It's Colorado who gets to decide that they are inconvenient. Okay. I have a note here and I'm trying to make sure that I think I got it right. Hope so. Okay, so here is a more specific example about for inconvenient forum. So we have parent A and parent B. Parent A assaulted parent B and the parties separated. Parent B received wounds to her face and and she needed 16 stitches. Parent B obtained custody in Minnesota and then moves to Michigan. 5 years later, parent A files a motion to modify the order in Minnesota, although the child has not lived in Minnesota for a number of years. The district court grants the petition of parent B to transfer jurisdiction to Michigan. Parent A appeals. The Court of Appeals finds that the transfer of jurisdiction was appropriate due to domestic violence and maltreatment of the children. And because one parent, the child, all the family and friends and all the social networks are there in Michigan, right? Not in Minnesota, because kids been over there for 5 years, along with school records. And if there's any mental health records, those are all going to be over there. And, one parent, all their work information and their mental health records, everything's going to be over in Michigan. The court examined all the factors, all those 8 factors, and parent B, while could have motioned at the request of parent B, and while they could have motioned to modify in Minnesota, they wanted everything to come to Michigan because they felt that for a variety of reasons that would be easier for parent B, and probably a huge piece of it is having to go back and forth between Michigan and Minnesota. maybe that Michigan court is also generically more friendly. So here again, we have a situation where we have one parent goes to Michigan, and there had been a court order in place. I'm going to assume that either parent A either actively allowed or just didn't do anything for 5 years when the other party had lived in Michigan for 5 years, right? And then decided, and I assume something happened that made parent A mad, and then they decided to file in Minnesota. But parent B was able to convince Minnesota to allow jurisdiction to go to Michigan based on those 8 factors. Okay, does anybody have any questions? I know this is like thick, heavy stuff, and that was coming in through my window.
We don't have any in the chat or the Q&A at this point.
Thanks, Jay. Folks, if you have questions, please just let us know. And if you think your question is kind of complicated, I think we can unmute people if that needs to be done. Jay can yell at me if I'm totally wrong. But please ask your questions, because we totally know jurisdiction is it's a bomb.
I will just say, I think I've had calls about this at least where someone, a party now living here has an existing order out of state. We get the call at Standpoint to give advice, and I think we can give advice on jurisdiction and what all this means, but this might be a case where you see that we are telling your client, the caller, that they need to seek legal advice in this other state as well. Because if they're bringing a motion out of state, like in our examples in Colorado, we're not licensed in Colorado. We can't give advice on bringing a motion there. So we can go over things like jurisdiction, but might encourage them to get legal advice in another state. And it's not because we don't want to help or want to pass the buck, but it's just a situation where we can't.
Yeah. No, absolutely. That's a really, really good point, Beth, that, and this can get really, these arguments are unfortunately difficult to make for pro se folks.
Yeah.
And we're going to really, and often people need to have attorneys in both states, one in, one in Michigan, one in Minnesota, or wherever they are, to make the arguments, to be able to try to get forum transferred. It's not easy. And I think that's the major struggle is, yes, there are options that exist. But in my experience, states are not super willing to want to give up their jurisdiction, has been my experience. But we want to let you know there are options out there, and that's how this kind of works. Okay. All right. So if you have somebody that you're working with and they move here to Minnesota and they want to register their foreign order, that's what they're called, and they're from another state. It always makes it sound like that they're from some other country or something, because we call them foreign orders, but they're not. They're just ones from different states. They could be from another country, but they're really mostly going to be from another state. And so it's really important, or can be really helpful, to register that order here in Minnesota, because it just allows for much easier enforcement if there's ever any sort of problems. And that enforcement could happen on an expedited basis. The same thing if you're working with a client who is moving to another state, and they, and in that other state, they also should probably register if at all possible. Things I do want to flag for folks when thinking about registering a foreign order. In all worlds that are not protective order worlds, when you go to register an order, you actually have to give notice to the other party, and they have an opportunity to object or whatever. There's rarely a strong basis to object, because normally you'd have to object saying the order itself is not accurate. Right. But they technically, not just technically, they will get notice. And they'll get notice of what county that you're filing in and all that kind of stuff. And so that's something to just flag if you're talking about somebody who maybe is fleeing. Their abuser may not know that they're here in Minnesota, or they may know they're in Minnesota but not know what county they're in. Just know that you will have to give notice to the other party, and they will have an opportunity to object. So they're going to know county and state where the person is. That is not true when you register a foreign order for protection or harassment restraining order. Under federal law, there is no notice in an order of protection or harassment restraining order. When you register those, there is no notice that goes to the other party. So just want to flag that as a difference, because advocacy may be familiar with the fact that you can register an order for protection and no notice would go to the other side, and then be surprised that that happens in a family court order. So just want to flag that for folks.
Yeah, and I think there's the one thing I would add is that, at least in my opinion, registering a foreign order is a fairly simple process. I don't think that's something that your client would necessarily need an attorney for. The process is all laid out in statute. It's something that we can help explain if you ever have a client who needs help with that. They would just need to get 2 copies of the order, including a certified copy of the order and basically a letter asking for registration. And again, just even if you register it here, Minnesota can't modify an out-of-state order, but they can use the laws of the state to help enforce it. And I think the idea behind that is you're not forum shopping. You're not asking Minnesota to second guess a decision. You're just asking for them to enforce an order that another state already made. Okay, so we're finally on to the second question that you can kind of ask yourself. Everything we just covered was if there's already an existing order from another state or a tribe or a foreign country regarding custody and parenting time. If not, if there is no prior custody order at all in place, and you have someone that wants to file for custody, or they're in a position where the other parent's filing for custody, the question to ask is, where is the best place to file? And so primarily that's going to be the state that is the home state, or the state that has a significant connection to the child. So we'll go over what those mean. So the UCC JEA uses the concept of a home state, and that's a really huge focus in that law. And it's defined as the state in which a child lived with a parent or a person who's acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. That state is the child's home state. And it's also the state that was the child's home state within 6 months before the filing, provided that at least one parent continues to live in the home state. If the child's less than 6 months old, it's going to be the state where that child has lived since birth. And if there's a situation where a family maybe moves away and then comes back, a judge can determine that that was only a temporary absence, and that the 6 months can still count towards determining what is a child's home state. And a child's home state is always going to be given really clear priority in the UCC JEA, and that is where you need to file that, that initial custody action. Yeah, so for the vast majority of cases, initiate an action in the child's home state. And so just a note, trying to clarify what I was saying on that previous slide about how basically what is called is extended home state rule, I think is how the UCC JEA applies to it or refers to it. That if a victim survivor, for example, flees the state with a child, the other parent can bring a custody action in the home state for up to 6 months, as long as the other parent remains in the state. So let's say, I think I have an example on the next page, but basically what I'm saying is if you have a client who maybe flees to Wisconsin, it doesn't mean that the parent remaining, let's say dad, has to file in Wisconsin. They can file here in Minnesota if it's been less than 6 months, because this will remain the child's home state. So typically a parent should not file in a non-home state unless there's an exception that applies. And so for instance, if the child resides in Minnesota with mother and father lives across the border in North Dakota, father should not be filing for custody in North Dakota.
And if say dad did file for custody in North Dakota, that's when it's really important for mom to raise one, personal jurisdiction argument. I don't know what kind of depending on the connections mom might have to North Dakota. And if there aren't any, then mom would argue 1, a personal jurisdiction issue, and 2, subject matter jurisdiction because child doesn't live in that North Dakota isn't the home state of the child. And so again, remember, personal jurisdiction, one can waive and can waive that fairly easily, but subject matter jurisdiction never goes away. So if mom, say, didn't know and kind of rolled with it for a while, and then things went, and then mom finds out that, wait a minute, we shouldn't be in North Dakota, mom can always raise the subject matter piece always. Let's see, we have a question from Dana.
Yeah.
If the child is 3 and has spent equal time with both parents in 2 states, parents were never married, which state would then have jurisdiction? Mom lives in Minnesota, dad lives in North Dakota.
Do you think that would tie to significant connection jurisdiction? Which,
yeah, we're going to actually, well, that's really, Dana, there's a Minnesota Court of Appeals decision that involves Canada and Minnesota that we're going to talk about in a little bit that I think will answer your question. If it doesn't, then bug us again, but I'm pretty sure we're going to get to it.
Yeah, really good question though.
Yes, it's a really good question.
Yeah, it's hard. Okay, so I was right. I did have an example that hopefully illustrates home state a little bit. But so again, we have a parent A and a parent B. Let's say that they and their baby reside in Minnesota from January to October. So Minnesota is the child's home state. Easy, right? But then it can become more complicated if parent A and the baby move to Wisconsin in November, but parent B remains home in Minnesota. This is the example where Minnesota is still the child's home state, and parent B will be able to petition a Minnesota court to establish a custody order. So likewise, let's say parent A is in a position where she wants a custody order and she wants Wisconsin to be the one to issue that order. I would say her best bet is to wait 6 months before filing a suit to establish custody. If parent B, so that's the parent who remained home in Minnesota, waits too long to file an action in Minnesota, they then have to file in Wisconsin instead, because after 6 months, Wisconsin becomes home state. I feel like maybe this ties in, we get a lot of calls about unmarried parents who've never had a custody order. And let's say in this case, it's mom who wants to move out of state with her child. And under Minnesota statute, she has sole legal, sole physical custody. There's technically nothing keeping her from moving because our move out of state statute only applies if there's court ordered parenting time. But the caveat we always give is that the parent who stays behind has that kind of big chunk of time to still file a custody action here in Minnesota, and the court here in Minnesota can make you move back. It doesn't mean that's going to be the ultimate order. The court can take their time to look at all the facts and give you permission to move, give that parent permission to move. But if the court is kind of acting off the cuff, let's say the parent who remains behind files an emergency order, Minnesota can easily decide they have jurisdiction and order that child and mom to return. So that's just kind of always the caveat we give when someone is asking for permission, or not permission, advice from us about moving out of state. That's what we mean by that advice. We're referring to the child's home state, and that Minnesota will hang on to that ability to be the home state and make that custody order.
Yeah, and just to be clear, actually, the court can order the child to be returned. The parent can go wherever they want. They just don't get to take the kid with them.
That's true. I guess just kind of in practice.
You want to move
mom coming back
Timbuktu without your kid? Go right ahead. I mean, as long as the other parent's going to take custody. But so the court can't make the parent come back, but the court can absolutely make the child come back.
Yeah.
And that's when we talk about this. This is why we're always like, if somebody wants to leave the state, it's very, 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 very important they get competent legal advice. Somebody who really understands family law, who really understands domestic violence, because while technically, legally, mom has sole physical, sole legal custody, it can go do whatever they want. However, Minnesota retains jurisdiction for those 6 months, and it really is going to depend on what type of, in our case, what type of abuser is on the other side.
Yeah.
Do we have an abuser who's going to file for custody? Well, then that's going to be problematic. Do we have an abuser who is way too lazy and is never gonna do that, then we don't have that. Do we have an abuse? Do we have a situation where mom and abuser were living together with child, and the kid is 8 years old now, and that parent and the other parent's been really taking care of them? Ooh, that gets really dicey, because you could get very angry court if you leave.
Yeah.
Do you have a situation where the kid's 8 years old and the other parent has been completely MIA? And then they're just doing this to be controlling? Well, that's a totally different situation. So it's so heavily fact specific. That is why you need competent legal advice around these issues. If a parent is talking about leaving the state with their kids, it's just not straightforward.
No, yeah, it's definitely a case where the context really, really matters, and at least trying to predict how a court could rule if a custody action was initiated. Okay, next thing is what Rana's already covered a couple of times because it's really important, but basically, what do you do if the other party files in the wrong state? Our advice is to raise the issue of jurisdiction immediately. And anything you file, it should be raising that issue, that jurisdiction, and then it's filed in the wrong state front and center, so that you are not waiving that, seem to waive that defense or not bring it up. It's just really best practice to bring that up immediately. And again, kind of going back to what I was saying before, if it's out of state, your client will need to seek competent legal advice in that state. And I think a question maybe we get, or I've heard from advocates, is, let's say in this case, dad files in North Dakota. It's definitely the wrong state, but the advice maybe mom is getting from other attorneys is, it's not that big a deal. Some state's going to make a decision. It might as well be North Dakota. So I think the question is, why is this important and why bother? Well, you want the right court deciding. You want it to be in a convenient location for your client. If Minnesota's the home state, they're the home state for a reason. They're the ones that have all that evidence regarding the child. It's the most convenient location for your client, and you just really want to set the precedent that Minnesota and not North Dakota, in this example, is the home state. Do you have anything else to add on that, Rana, about why it's important or what else they should do?
No.
Okay.
We do have another question that was popped up in the Q&A. The question is, what if the mom moves without telling the other parent, but she has sole legal and physical custody? Right. Would that look bad on her in the future if there was ever a custody case filed?
Super depends.
Yeah, I think that's another thing where the context like Rana gave the example, like let's say a mom has an 8-year-old and dad's just been absent, not interested, never tried to, not a part of the child's life. I think that's a situation where you're not going to expect mom to give that notice that she's moving out of state. He might still get mad and try to file custody action here, but the court will see that context. If hopefully, Rana made a face. I hope they see that context. Let's say it's a case like Rana said, where parents are living together, raising the child together. Again, there's nothing in the law saying she has to have that permission if there's no court order parenting time. But yes, I do think that's a case where it could look very bad to the court that mom took off with the kid from a parent who's been involved every day. And that could play into the best interest factors, right, when the court is eventually making a decision about custody and parenting time.
Good question.
Yeah.
Yeah, and that's again why we encourage folks to seek competent legal advice, because it's very fact dependent.
Yeah, and we get that question all the time. Okay. Okay, so just a quick note on divorces. It's a little different, that you might find that even if a state has jurisdiction to enter a divorce decree, it may not have jurisdiction to order on custody and parenting time. So there's some times where parent A may file for divorce in North Dakota if he meets North Dakota residency requirements, but North Dakota couldn't decide custody or parenting time in that divorce if Minnesota is the home state of the children. So I had some divorces when I was practicing where we had to maybe reserve issues of custody and parenting time, but one state could enter the divorce decree, decide maybe some financial issues, but not custody or parenting time. So just a quick note on that, nothing we want to really focus on.
All right. So what happens if we don't have a home state, or we have something like what Dana raised about how we have a child that's been living half-time in Minnesota, half-time in North Dakota, and they're under the age of 5, so they're not in school. So we don't know where they're going to school, right? Because that's often a helpful determination on where a home state is. So what if we don't have a home state? I've also worked with clients over the years who didn't have a home, their kids didn't have a home state because they moved so many times. Like, you know, every 3 months they were going to somewhere else, and or that can happen sometimes in military families. Happens a lot in sex trafficking, to be fair. There are a number of different reasons why why a child may not have a home state. And so in that case, then the state could assert what's called significant connection jurisdiction. But they can only do that if there is not a home state, which means the child hasn't been in one place for longer than 6 months. So there's not a home state, or they had been somewhere for 6 months, but since then they've moved so many times, it's been more than 6 months since they've been there. So there's not a home state, and the child and at least one parent have a significant connection with the state other than mere physical presence. So more than just they're here now. And there is substantial evidence regarding the child's care, protection, training, and personal relationships. So we're going to be talking about, you know, they now are here in Minnesota, because that's when we're normally going to care about it. They're here now in Minnesota. They don't have a home state. Child doesn't have a home state. And they are living here, not just they showed up here. And so living here kind of things are going to, again, does the parent have a job? Is the kid enrolled in school? Is there daycare? Are they getting benefits from Minnesota, whether those be welfare or otherwise? Are they, what other kind of relationships are here? Is there family here? Is those types of things is what the court should be looking at. So I think we have an example, right? The court, when they're considering significant connection jurisdiction, they have to consider how long has the person been in the state and what's the evidence that exists here in the state. Teachers, counselors, therapists, healthcare providers, relatives, what evidence is here in Minnesota? For example, we have, and this was actually, we talked about this last year at New Laws, if I remember. We had a situation where, that's actually the next example, so I'll just wait. So times where you may see this is people are traveling between states, military service. You got a kid who's under 6 months who's lived in multiple states. And then we had a case that came down out of the Minnesota Court of Appeals last year. We did talk about it at New Laws. But what we had is we had mom and dad. They were living here in Minnesota. And mom and dad moved to Manitoba. They were married, and they had moved to Manitoba. They moved to Manitoba because dad was fleeing a felony charge. So he was a wanted felon. But they moved to Manitoba. Surprise, surprise, the relationship kind of fizzled out. In case you're wondering, the felony was not domestic violence related or sexual violence related. The relationship had some problems, and mom ultimately returned to Minnesota with the child. After that, they shared responsibility. The child was under the age of 5. And so the child was living on a 2-week rotating basis, half-time here in Minnesota, half-time in Canada, up in Manitoba. Mom, after she had been living in Minnesota for 6 months, because you gotta live in Minnesota for 6 months to be a resident and to be able to file for a divorce in Minnesota. So after 6 months, she files for divorce here in Minnesota. Dad, who was unable to return to the United States because there was a warrant for his arrest, didn't go over very well at the Court of Appeals. But he was like, but I can't come to Minnesota. And they're like, you can't come to Minnesota because there's a warrant for your arrest. That's not the best reason. Not the best reason. Dad challenged jurisdiction under the UCCJEA. And ultimately, the Minnesota court said that while Minnesota was not a home state, so we had this because the kid was living in Minnesota and in Canada equal amount of time, just like in Dana's example about how the kid has been living in Minnesota or North Dakota equal amount of time. The court said that Minnesota wasn't its home state, that it didn't have a home state. Right, this is an initial determination of custody. So no child did not have a home state at all, but ultimately said Minnesota could assert jurisdiction based on the significant connections. That in this particular case, the child had lived all but 9 months of their life in Minnesota. That's how long they were up in Canada. And mom was down here and mom had a job. And honestly, I think largely in this circumstance, mom filed first. So sometimes there is that who files first when you have this kind of like, which state could it possibly be? Mom filed first. And so Minnesota was argued it had significant connection jurisdiction, and that was upheld by the Court of Appeals. So I would say that, again, some of it's, we got a child that's 3 equal time in Minnesota and North Dakota. If it's always been for the whole 3 years equal time, some of that's gonna be, I think, who gets to the courthouse first, quite honestly, because the amount of evidence is gonna be the same, probably. But they're gonna look back at those factors about how they're gonna determine whether or not which state has more of a significant connection. So did that answer your question, Dana? Hopefully. Perfect.
Great.
All right.
Okay. So just a quick slide on in the few cases, what if there's no home state and there's no state even with a significant connection? There is another basis for jurisdiction that's called like last resort or vacuum jurisdiction. And it's available that a state can assume jurisdiction if no state can say that they're a home state or has a significant connection. And basically, just in a kind of a vague example of that is if a family has traveled from state to state with only really brief stays in one place, it may be necessary for a court to exercise this kind of jurisdiction. So I'm not sure how common this actually is, where a state wouldn't even have significant connection, but it is an option.
Like, just circuses don't really exist anymore, do they? Or they like travel from state to state to state to state to state like they used to? Like,
not that I know, but yeah, you can kind of think of it that way.
Wait, sorry, I just watched an episode of Call the Housewife or the Call the Midwife, and there was a circus episode. And so anyway, moving on.
Yeah, so this is for traveling circus families. Okay, and then kind of this is the third question. If you're going back to our list of questions to ask yourself, so if you find a state that should have jurisdiction, are there circumstances where that state can say they want to transfer or decline jurisdiction? And one of those, Rana already went over, I think in detail. It's the last one down there in yellow, that state that has jurisdiction can decide that they're in inconvenient forum. But there are also a couple other ways. One is that in the case of emergency jurisdiction, and also in the case of unjustifiable conduct, which is also known as clean hands, the clean hands doctrine. And I think our next slides focus on emergency jurisdiction and clean hands, and Rain is going to cover those, so I won't do much more on those right now.
All right, so emergency jurisdiction. This is a situation where a state can take only temporary jurisdiction. It could potentially lead to home state jurisdiction, but it's normally only going to be very temporary. So it is the state with one state can exercise emergency jurisdiction if the state that has home state jurisdiction or exclusive and continuing jurisdiction declines on an inconvenient forum. or if there's no prior order and there's no current proceeding in the home state, an emergency order will remain in effect until the home state either issues an order or the emergency state gets jurisdiction after 6 months. So that's if there isn't any sort of orders in place, or if there is an existing order, the court can issue an emergency order for a short period of time, and then it has to communicate with the other state. And then in that communication, the goal is to resolve the emergency, protect the safety of the parties and the child, and determine how long that temporary order is going to exist for. So we see emergency jurisdiction mostly in, I see it, this is where I normally see it, is in order for protection cases. Because again, remember how I said that any sort of, that if you get an order for protection and it establishes, it says something about custody or parenting time, that could be an establishment for UCCJEA purposes. If the same thing is true when we're talking about emergency jurisdiction. So domestic violence victim flees to Minnesota from Texas and always does so in January. I will never understand why. Cold here, and it's not cold in Texas. Except as long as you don't count March of this year when they had that cold snap. But anyway, so domestic violence victim flees from Texas up to Minnesota and files for an order of protection here in Minnesota. There is a custody of parenting time order, whatever they call it, down in Texas. There's already an order involving custody and parenting time down in Texas. Flees to Minnesota, files for an order of protection here in Minnesota, and essentially is asking the Minnesota court to take emergency jurisdiction because it's because of the domestic violence that's happening in Texas, and that Minnesota is safer. And so that emergency jurisdiction, Minnesota, if Minnesota grants that, even the ex parte order for protection, Minnesota then has to have conversation with Texas. So the Minnesota judge who is issuing that order has to now call down to Texas and talk to the judge in Texas who oversees that court order, and they're going to have a conversation. And they're going to decide through that conversation if Minnesota can keep emergency jurisdiction for any period of time or what's going to happen next. And so you have, sometimes we have victims who flee a state, and, so they're fleeing Texas to Minnesota because they have heard or they think Minnesota is going to treat them better in family court because they have this wretched, horrible judge down in Texas who is just, horrible, as they feel that it is, and they're coming up to Minnesota thinking it's going to be better. Well, the Minnesota judge is going to be talking to that, horrible Texas judge because they have to by statute. And so it may not work to their advantage at all in that circumstance. Yeah. So keeping in mind that those conversations have to occur, and what Minnesota could ultimately do, because Minnesota doesn't have a residency requirement for seeking an order for protection. You could issue the order on behalf of, in my example, mom, but not issue but order that custody provisions as ordered in Texas are continued to be followed. And that's definitely a possibility. So emergency jurisdiction is there. It also could be a situation so there aren't any court orders in place. Mm-hmm. Mom, or dad flees to Minnesota to escape domestic violence from Texas. We have no court orders. And so they apply for an order of protection here in Minnesota so that they can get at least a temporary custody order, an emergency custody order. And then they wait out their 6 months waiting to see what is the other party going to do. Are they going to file? Are they not going to file? It can be kind of risky because you're putting up a big spotlight into the sky about, hey, here's this thing that you could do down in Texas, right? So things to think about, but emergency jurisdiction, while it is a thing, is definitely not, it's the beginning of a conversation. It's never the end of a conversation. I don't know, Beth, if you want to say anything else about emergency jurisdiction.
I don't think so. Let me look at my notes quick. Yeah, no, I think you covered it. Just there's a big note in the UCCJEA that requires the communication between the states. So they're aware that there's simultaneous proceedings and that basically that order, let's say you flee to a new state and like Rana said, and file for emergency custody here where there's no existing order. Yeah, that new state, that's a case where the emergency order could become permanent because the state could become the home state, but usually think of emergency jurisdiction as temporary, just to kind of cover a gap and make sure things are safe.
Yep. And yeah, and it's, one can file an emergency jurisdiction custody petition, like a separate one. I just normally see it happening through orders.
Right. Yeah.
Unclean hands. Oh man. These are the things that, like, as lawyers, we get like all weird and geeky over because we learned all about unclean hands in law school, but never in real life do we ever actually get down to unclean hands. But the idea of unclean hands is that the party who is now trying to argue that a state has jurisdiction, that they've done something naughty to get it. So for example, domestic violence perpetrator, so abuser, takes the kids, and we don't have any court orders here in Minnesota, takes the kids, runs and hides. It happens to be hiding in Wisconsin. It's hiding in Wisconsin, no communication, nobody knows what's going on. They're actually like potentially even charges pending in Minnesota, but is in Wisconsin with these kids hiding, and then waits 6 months, pops up in Wisconsin, and then applies for custody and said, well, Wisconsin's now the home state. These kids have been here for 6 months. So, forget you, Minnesota. You don't have any jurisdiction here. That would be a time where, in that case, mom would argue that the abuser has unclean hands because they've engaged in unjustifiable misconduct to be able to get jurisdiction. The UCCJEA does have very specific comments about how domestic violence victims should not be accused of unclean hands for conduct that occurred while they were fleeing domestic violence. So that's why I use the opposite example. And like I said, I've personally never seen this argued. I don't know about if you've ever seen it argued. So, and I think we have a big list of cases from across this country, and like there's only one.
I think there's only one example. If you ever do get a case where unclean hands can be proven, the court declining to exercise jurisdiction because of this wrongdoing can assess against the party like fees for costs, communications, attorney's fees, witnesses, travel expenses, childcare during the course of the proceedings. So there can be all kinds of consequences if somebody does wrongdoing to try and get jurisdiction in a new state. It's just, obviously, it doesn't seem between us that it's something that happens a lot, but just we wanted to mention it just in case. Yep. Yeah.
Because it's a thing.
It's a thing.
All right.
Okay, I think our last few slides here are just kind of tying up some loose ends, just things that maybe would be of interest. One is just, if you do get an order for protection, how can it be enforced across state lines, and can it be enforced across state lines? And so the answer is that yes, it can. So at least in Minnesota, there is a statewide database that OFPs can be entered and they can be enforced in any jurisdiction within Minnesota. And then federal law also requires all states, so obviously including Minnesota, to give full enforcement. So they call it full faith and credit to orders for protection, and that includes the tribal order for protections.
When it comes Canada.
Now Canada.
Yep, and we'll talk about that in new laws, but now Canada too. So not just full faith and credit across the United States, it also includes Canada.
So US, our territories, Canada, and tribal OFPs. And just a note on tribal OFPs, those are enforceable even if the protected person or abuser is located on or off the reservation, tribal lands. And also a note I have for myself here is that right now, it seems the note I have is that tribal nations don't have direct access to that statewide database to enter their tribal OFPs. They can be entered into the state court systems file, but if a tribal OFP appears valid, state law enforcement must treat it as valid and enforce that tribal OFP. Oh, and also just an interesting 18 U.S. code here that crossing state, territorial, or tribal boundaries to violate an order for protection may result in federal imprisonment.
Yep, it's a federal crime if you're crossing boundaries to do it.
Yeah. And then just a couple notes on tribal court. That there are 13 tribal courts that operate here in Minnesota. They have their own sovereignty and have their own laws that govern all legal proceedings. And that can include family court, orders for protection. We just talked about tribal order for protections. That can be frequently referred to as their domestic relations code. And their domestic relations code includes laws dealing with child custody, child support, spousal maintenance, division of property, and how the tribal per capita payments, if any, are characterized in the event of a divorce. And just our last note on tribal court when it comes to these issues relating to children, that the tribe will have jurisdiction, so exclusive jurisdiction over child custody proceedings if that child resides or is domiciled within the reservations, except for where jurisdiction is otherwise vested in the state by existing federal law. I think that's more complicated than we want to go into, something we can discuss separately if it comes up, but just a note there. And if the child is a ward of the tribal court, the tribe retains exclusive jurisdiction, notwithstanding the residence or domicile of a child. So those are circumstances where the tribal court would have exclusive jurisdiction. I think otherwise, if you're registered as a member of a tribe but live off the reservation, there would be a choice of filing in tribal court or in state court and just assessing at that time which one would have the most benefit. Did you have anything else to add to that, Rana, to the tribal court portion of things?
No, I don't think so. Tribal court, for those who are even remotely familiar, is that's its own training all within itself.
Yeah,
and, and every tribe operates separately and differently. So obviously, I mean, it's no different than every state operates differently. They're their own sovereign nation. So it's hard to talk generically about tribal court because we have 13 of them and they all operate differently. In the same way, it can be difficult to talk about even what's happening in Minnesota courts because we know that all of our counties operate sometimes differently depending on what the issue is. So,
yeah.
All right. So what questions do folks have?
Yeah.
Are we just unbelievably brilliant in our explanations?
I don't see any, but if anyone wants to raise their hand, I can give you the opportunity to unmute if you'd like to ask a question. I don't see anything coming in.
All right, sounds good. Well, maybe folks are typing, so I'll say this while they're doing that. I just want to remind folks that, Standpoint is here when we talk about, needing competent legal advice on these issues. We are always welcome to be that competent attorney that can help give that legal advice. I think we're fairly competent most of the time. No, I think we're fabulously competent. But whether you use us or you use some other attorney, just make sure that they're competent and understand family law and the dynamics of domestic violence or sexual violence as they're giving their advice. But we are here to support you guys in whatever you're doing, and however we can be helpful, please let us know. And I think we did just get a question, which is fabulous.
Yeah. Do you want me to read it, Rana? I don't know if you can see
Yeah, if you got it up, do it.
Yeah, it says for OFPs, if the petitioner filed in Minnesota but moved to Illinois, petitioner filed in Minnesota but moved to Illinois and the respondent crosses state lines to violate the OFP, the police tells the petitioner to call Minnesota to file a police report. Okay, so they tell them to file where the OFP is. When this happens, what should we as an advocate do to assist the petitioner?
Well, I think you can assist them in filing or, making the police report here in Minnesota, although they should be able to also apply, make the report in Illinois. That also might be a circumstance where you want to help the petitioner figure out how to register their order in Illinois. That might help in enforcement in Illinois too, as another thing to think about. But yeah, I mean, even now it's probably even a little bit easier because we've gotten more comfortable with things like Zoom or whatever for that petitioner to be able to file a police report here in Minnesota. The advantage of filing it in Minnesota is, and there is actually a pretty significant one, is that if she files in Illinois, they're never going to extradite him to Illinois to charge him. Like, that's not going to happen. It's a misdemeanor. So basically he just can't come to Illinois and happens to get picked up on the warrant. If she files here in Minnesota or makes the police report here in Minnesota, they can charge him in Minnesota. And then that's a lot easier to go through that process of prosecution. So yeah, definitely there are strong reasons for wanting to kind of go through that annoying hoop of filing that police report here in Minnesota.
Yeah.
There's another question. Oh, sorry. There's another question. So what is your advice instead of registering order in new state if they don't want offender to know where they are?
If they don't want the offender to know where they are, they're not going to be able to register their family court order, not their order for protection, but their family court order. Right. They're just not, they won't be able to get enforcement from that state. They wouldn't be able to anyway, because if they tried to enforce, then the offender's going to know where they are no matter what.
Exactly. So yeah, so the only time you'd register is like if you want, let's say Minnesota's a new state, you register it here because you want Minnesota to hold the other parent in contempt for not following the order, for example. If that's just not a factor in that case, like they're safely in a new state, there's no contact at all, there may not be a benefit to them to registering at all.
Good.
Yeah. And the one thing I was just going to say about orders for protection is if the law enforcement in the new state just needs a reminder that it is applicable in their state too. You'll see on every order for protection, there's a bunch of boilerplate language that you probably don't read. I don't read it, but part of that language on every order is the language that it has to be given full faith and credit in every state and territory. And so just it's already on the order that can be cited to the law enforcement in the event you do want them to be aware of that.
Yeah, and that might be a good time if the victim survivor is having a hard time with law enforcement. It might be worth reaching out to whatever the local advocacy is that covers that county, or the advocacy that's in that county in Illinois or wherever it is, and having a conversation with them and seeing what kind of relationship they might have with law enforcement. Maybe they might be able to, make some things happen. I know that there's a lot of our programs that have really good relationships with their law enforcement, and sometimes calls from them can make a very significant difference. So remember to use your relationships, or build relationships if necessary in other states to help make that happen sometimes. Minnesota advocates are far superior than any other state's advocates, but.
Another question too, do you have resources for advocates who aren't versed in tribal court, but have to work on a case there? Do you have any suggestions?
I think we have a YouTube video, don't we?
I think so.
I would also say reach out to the coalition, there's the Minnesota Coalition Against Sexual Assault, and then there is Sacred Hoop Coalition, which is the Domestic Violence Coalition for Native Programs. And also reach out to your Native program. Almost all of the tribes a number of the tribes, not all, but a number of the tribes have their own domestic violence, sexual violence programs that are on the reservation. And so also reaching out to them those are all really great resources.
Yeah.
I don't see any other questions coming in here.
Minnesota Indian Women's Sexual Assault Coalition. I don't know how I just totally screwed up MUSAC's name. So sorry to MUSAC. Minnesota Indian Women's Sexual Assault Coalition is their correct name.
There we go. Okay.
Sorry. All right. Well, as always, you guys, we are here to support you. So if you come up with questions later, you just didn't feel like typing it out, you're always welcome to give us a call. We're always happy to answer your questions. Whatever we can do to be supportive to you. So let us know, email us or call us, text us. Pigeon, don't pigeon at this point, because if it goes to the office, I can't guarantee somebody's there. So, but reach out to us. We're here to support you. So let us know. Otherwise, Beth, do you have anything else?
No, thank you so much to everyone. And again, thanks for the idea for this presentation. And we're always happy to hear from advocates. So call or email anytime. Both of our numbers and emails are up on the screen right now.
Yeah, absolutely. Jay, is there anything else from your side?
No, that's all. So if there are no more other questions, I'll end the webinar. Thank you to Rana and Beth.
Yes, thank you. Thank you all so much for joining us. Have a great rest of your day.
Yeah, thank you, everyone. Bye.